Lori. I'm the Executive Director of Housing Court Answers. Thanks for joining us this afternoon. We do these presentations for folks who are interested in what's going on in housing court. We have a series of workshops through the year. This afternoon, we have Judge Stoller, who's the Citywide Supervising Judge for the New York City Housing Courts with us. I just want to quickly say that Housing Court Answers has a website with a lot of information on it. We have information tables in the city's housing courts. The three that are open on a limited basis for now, at least, are Brooklyn, the Bronx, and in Queens. And we have a hotline where we take questions 9 to 5, Monday through Friday, about housing court. We can give people information about their cases, what's going on in housing court, how to access housing court, and other information, some of which I hope we'll get today from Judge Stoller. So most of you, I hope, or all of you, will be kept on mute through most of this meeting. If folks have questions, once Judge Stoller's ready to answer questions, can you please put them in the chat? As we have in the past, we've asked that this meeting mostly be for people who are advocating for tenants facing eviction, and that certainly anyone who doesn't have an attorney is welcome to put a question in, but please don't ask questions about a specific case or questions that are about really complicated legal procedures. This is mostly, as I said, for the advocacy community, folks trying to prevent evictions. So with that, I'm going to just say that Judge Stoller is with us, joining us this afternoon. As most or all of you know, Judge Stoller is the Citywide Supervising Judge for the New York City Housing Courts. And I will hand it over to Judge Stoller.
Hi there, welcome. Thank you very much for having me. I know there are a lot of questions and we'll get to it. I guess I'll just give kind of an overview of what's going on. I guess what I'll say is that housing court has gone through a huge amount of change in the past several years, and that's not done. The court is still changing. It's changing in terms of technology. It's changing in terms of the way the court operates. It's changing in terms of availability of attorneys for tenants. Right now, the state of the court, I'll give a brief overview on what's going on, and with the caution that because the large amount of changes that we're going through are still going on, what I'm saying is might very well not be the status quo in the future. Right now, as opposed to other times earlier in the past couple of years, court appearances are presumed to be in person, but it is possible to appear virtually if you can get an accommodation from the judge from a disability and sometimes for other reasons too. And I know there are questions about that, and we can get into that later. Right now, the way the procedures are for cases that have started is that at the beginning of the case, a tenant appears at what's called an intake part. In the Bronx, that's a separate court part that's virtual. And that's a part that's staffed by a legal services provider that's on for the day. And the case gets automatically adjourned to give the tenant an opportunity to meet with the legal services provider and see if there can be representation. In counties besides the Bronx, the intake part is in person in a regular court part, and that's where that process happens. After the tenant gets a chance to talk to the legal services provider, there's an adjournment. I know that another issue that I'm sure that we're going to talk about today is the fact that legal services providers are not in a position, I think, where they can represent everybody. And that's a genuine problem that I'm happy to discuss. But what the procedure is for the tenant to meet with the provider, the case gets adjourned, and then we come back and see if it's possible to get the tenant representation. After that, if not, the court has some discretion in terms of further interventions to try and see if that can be done. The other big issues changing the court are technology. Much more is electronic with the court right now, not just the virtual appearances, but also NYCEF, which is the New York State electronic filing system. So a lot more is going on electronically, which can increase access for a lot of folks. And Another big issue that's still going on and taking up a lot of energy with the court are ERAP applications. I presume that folks know what that is, but that's Emergency Rental Assistance Program. And filing of an ERAP application has the effect of staying the housing court proceeding for the state to determine the eligibility of the person who applied. That's mooted out a lot of cases, not all of them. Sometimes money gets paid, sometimes if it gets paid, it doesn't necessarily resolve the case. And there are some cases where landlords have been making applications to vacate the stay based upon the particular facts of the case. That's sort of like very basic summary of what's various things going on with housing court right now. I know there are a lot of questions, so I'm happy to just defer to those at the moment.
Great, thank you. Yeah, so just to repeat what I said earlier, if folks have questions, please put them in the chat. We're not going to be unmuting folks so that you can ask directly. So if you were raising your hand, please just put the question in the chat. And I am going to, the first question, of course, is a super long one. With the overload on legal service providers, the right to counsel is materially inaccessible to a lot of clients. Often clients are given a number to call, and when they call, they are told attorneys can only act as an advisor and not actually represent them. And yet the proceedings are still pushed forward by the landlord's lawyer. This was addressed briefly during the talk, but is not in any real sense a right to counsel. Is there any talk of staying proceedings in the cases until counsel is provided?
There have been a lot of requests for that. A lot of elected officials have requested that, and a lot of the legal services providers have requested that. The New York State Legislature did stay cases throughout basically 2020 and 2021. The New York State Legislature let that moratorium lapse. So right now, that's not a policy of the court to stay cases. That's left up to the individual facts of the individual case. So based upon the case, a judge can stay or adjourn a case to try and get counsel for a tenant. You're correct that a lot of the legal services providers have experienced the same kind of, I guess you might call it the great resignation that occurred in this country throughout 2020 and 2021, where they lost a lot of staff. And because of that, they weren't able to represent everyone that was supposed to have been represented. So that's the status right now. There is a working group that the chief judge of the civil court has with various legal services providers. In fact, we had a meeting earlier today where we're trying to work out some sort of solution, because the legal services providers, I think, based on the time of the year, it having been after graduation from law schools last year and the bar exam, have actually done a lot of hiring. So they're in a somewhat better position now to represent tenants than they have been earlier this year. I think the big problem right now is getting the newly hired attorneys trained to a level where they can actually take on a caseload that can be adequate to represent everyone who the legal services providers have contracted to represent.
I think if I could just pile on that question a little bit, is that one of the things that we hear is some confusion about this. So, you know, Office of Civil Justice has, they have personnel in the courts. There's sort of this intake process, and tenants are steered through the intake process. But then it's not like we talk to tenants who don't always know whether they were getting advice from someone or whether they were getting representation. They call us with confusion. I know other organizations get that as well. So I'm just wondering if you can like talk a little bit about like how many people are actually getting representation compared to the number of people who have cases in housing court. I'm not going to sugarcoat. There are a lot of tenants who are not getting representation. In terms of confusion, unless you sign a retainer agreement, you don't have a lawyer in the case. I think that my understanding of the statute that establishes the program does say that everyone gets advice at the very least. So I think that there are a lot of tenants who are getting advised by attorneys, but do not have
an attorney put in a notice of appearance for them. I'm sorry, the other question was?
No, that's just sort of like,
Yeah.
one was how do they know, like, and then also just, how do we know when we're talking to folks, how to distinguish? Most tenants don't know what a notice of appearance is and don't.
Sure. I mean, for an attorney to represent you, the legal services providers have a retainer agreement that the tenants sign. So if they sign something that says such and such organization is my attorney, then you have an attorney. If you haven't signed that, you don't have an attorney representing you in court.
There are a couple of ERAP questions, and I'm going to combine them a little bit. One is about the program itself, and we'll understand if you don't want to answer it. Is there a maximum amount of times that you can apply for ERAP if you didn't get the maximum amount allowed in the law? And then the second question on this is from an attorney, I think in the Bronx, who said that while appearing on behalf of a client who had filed an ERAP application, she was told by the court attorney that they were no longer automatically putting cases off calendar for tenants who had filed an ERAP application. And is that true?
So the ERAP statute says that filing an ERAP application effectuates a stay pending a determination of eligibility. So if you apply for ERAP and you get it, or maybe you don't get everything that you asked for, it is possible to apply again. That's my understanding of the law. That's the first question. In terms of the second question, because it says, and this kind of relates to the first question actually, because we've seen cases where tenants have applied for ERAP, have gotten ERAP and then applied again. And under the statute, does that mean that there has been a determination of eligibility, or does it not mean there's been a determination of eligibility? This requires an interpretation of the statute. An interpretation of the statute is something that judges do. It's not something that clerks do. So that's correct that a mere filing of or notification of ERAP does not automatically mean the case is stayed until a judge has had an opportunity to put a judge's eyes on the case and see that there has not been a determination of eligibility or something. In other words, it's not for a clerk to decide. You don't want a clerk making an interpretation of the statute and deciding, oh, this must be a case where the stay applies, or this must be a case where it doesn't. Instead, that's a function of the judge. And if there has been a pendency of an ERAP application and no determination of eligibility yet, then under the law, the case is stayed.
We've had a bunch of questions when people registered about the Americans with Disability Act and the accommodations that the court is providing. And at Housing Court Answers, we've had a lot of, to put it politely, battles with the clerks. Can you talk a little bit about what kind of accommodation tenants can get when they're filing their answer for their non-payment case? Number one, and then number two, how the process works for someone who needs an accommodation to appear virtually or some other accommodation for the actual case.
Sure. First, there's two kinds of ADA accommodations. One kind is something that a clerk can do, and one kind is something that a judge can do. So, for example, if you are hearing impaired and you need special kinds of headphones that they have as an accommodation in the court appearance, that's something that a clerk can do because that doesn't affect the judicial proceeding. If it's something that affects the judicial proceeding, like a virtual appearance, or for example, if you have a disability where you're having a trial, but you can only sit for a short amount of time, that's something that affects the court proceeding. So that's not a clerk's decision, that's the judge's decision. The clerk's decisions ultimately get rooted to the chief clerk, whose name is Aliyah Razak, who is also the chief ADA. I forgot the specific title, the ADA coordinator, I think her title is. So if it's something like, if it's a request for an accommodation that she can do, like the first kind I talked about, then she can grant that accommodation. If it's something else, then she gets in touch with the judge and lets the judge know that there's been a request for an accommodation, and then the judge makes the request. So if someone is making an ADA accommodation, there's a number of things that the court needs to see. The court needs to know what the disability is. The court needs to know what the accommodation is. We need to know the name of the case. The index number is also helpful. The court date is something that we need, and we need contact information for anyone who's requesting a disability. The court may or may not grant a disability. Sometimes I do, sometimes I don't. It depends. I mean, these cases are very fact specific, so it kind of depends. Sometimes things that seem like they should be ADA accommodations are not. Like if you're caring for an elderly person or something, that as a matter of law, the ADA doesn't actually apply to that situation. Doesn't mean that you can't ask for an accommodation, but that's something that comes up. This is kind of a big subject, Ms. Laurie, so I don't want to skip over something you said, and I just want to come back. Was there something that you asked about that I didn't, because I feel like I missed something, but I just want to.
Yeah, so one thing, as I said, we've been having sort of battles with some of the clerks about is when someone calls the number, or I'm not even sure how the many ways they contact the court to ask for an accommodation to file their answer, and they'd like to answer by phone, either because they're homebound or have some disability. That one of the first calls we got was from a tenant who was blind. So they want to answer by phone. And of course, during the pandemic, tenants were permitted to answer by phone. And so I think a lot of people understood that that was something that the court could accommodate or use as an accommodation. And now what's happening is the clerks are mailing the answer in writing form to these tenants. And for those who don't know, doing an answer in writing is not any easier from my perspective than going to court to file an answer, right? So it has to be notarized, it has to be served, it has to be filed with the court. So we're just wondering, like, what's the barrier to letting everyone file their answer by phone? I know that's a big pain in the neck for the court, but it would be so much easier for most tenants. It's like, how is that an accommodation to give?
We have a desperate shortage of clerks right now, and that makes it very difficult to take answers by phone. In addition to that, taking answers by phone, the discomfort with that is we have no idea who's calling. I mean, I guess you could say we have no idea who shows up to answer, but we've had situations where people show up and they're like, I don't know who this person is, who, you know, I mean, it's not that you can't do it. It's just that it exposes the process to some flaws and some trickiness. So what's going on right now, and actually Aliyah Razak, who I think is going to actually, Ms. Laurie, have a conversation with you, I believe, coming up. This is her field of expertise more so, but from what I've talked to her, this is my understanding of what's going on. And I'm looking at the email that she sent me where she answered this question. What Aliyah Razak said is that if someone requests that answering without having to come to court, they're sending written answer forms and an affidavit of unavailability to someone who wants to answer by phone. The thing about the notarization, answers don't have to be notarized. And I looked at the directions that get sent out. The directions do say that. That's incorrect. I've talked to Aliyah Razak about that and asked her, can we change that? Because answers do not have to be notarized. So to the extent that was communicated before, that should not have been, and that's wrong. So answers don't have to be notified. In terms of service, in addition to that, what Aliyah Razak said to me is that we're not asking tenants to serve the answers right now, that we're at the point of putting them on NYCEF to relieve tenants who are making accommodation requests from having to do that. So it's just a question of answering and getting the answer back to the court. So there are situations where answers are taken by phone. I'm looking at the email that Aliyah Razak sent me, but it's for situations where there are accommodations. And like I say, Aliyah Razak, this is her field of expertise, and that's all that she said is that, okay, when it was someone who called with a very specific situation, like you were talking about, like the person who was unable to see, called up. I think that was an instance where on that specific fact scenario, they took the answer by phone. But because of the challenge it presents with our staffing right now, it's limited to someone who's like in that kind of situation.
Yeah, that all makes sense. Thank you. Yes, we've had a number of questions too about the services in the courts, just in terms of going from the pandemic period when legal service providers had no offices in the courts, HRA, the rent administration folks who help with one-shot deals and other things were not in the courts. Can you just talk a little bit about, which courts are going to be expanding their services that are offered? I know, like, we're not back in the Manhattan Housing Court yet. I know HRA's RAU, or I shouldn't use RAU, but the rent administration folks who help with one-shot deals are not back in all the courts 5 days a week. The help centers aren't open 5 days a week. I'm just trying to think of things that used to be in the courts that were really helpful to tenants facing eviction and to advocates who could say, here you can apply for a one-shot deal by going upstairs. Can you talk a little bit about how those services might?
Yeah, we really want rental assistance back in the court. We want the help centers back up and running, and we want the providers to have offices. Right now, let's just keep this between you and me. This is just between us, but housing court is sort of like, the stepchild of the court system. We compete for resources in facilities with lots of other courts. And so, for example, in Manhattan right now, we share a building with criminal court, with Supreme Court, with civil court, and rooms that we used to use for some of these services like rental assistance or legal services offices have been claimed by other courts who are coming in and like poaching our territory. So these are all these sort of like administrative fights that we're having that are deeply unpleasant, and that we're trying our best to secure services for people who need them, because we do need them. So I think that what's going on with a lot of the courthouses right now is that legal services providers are sort of being put into one office, whereas before it used to be the case that like legal aid had a separate office and legal services had a separate office. In terms of the rental assistance units, I lost track of what courthouses are what, but I know some of them they're up and running and some of them are not. And one of the challenges with that is that rental assistance, the workers who do that, they're all union and they all have very specific requirements about their workspaces. And those specific requirements are not necessarily what's in the courthouses. So it becomes a big logistical question about, it has to be equipped with like this and that. And this kind of wiring has to go in for their computers. And we have to have like this amount of window space or something that, courthouses are sadly windowless places. So, and I know that we had these offices up and running before, so you think that we should just be able to get them back. But a lot of that space is being fought over with other courts right now. So I mean, what I can tell you is that, and I'm sorry, with the help centers, the challenge with that is help centers are staffed by court attorneys. And just like the legal services providers have lost a lot of attorneys through attrition, so has the court system. We're down a good, I think, system-wide, a good like 20, 25 court attorneys, and the hiring is kind of trickling in, and it's hard to hire them. So we're kind of stretching court attorneys between the help centers and working with judges and the parts and so forth. So a lot of this is about resources. A lot of it's about the resources that we've lost with the pandemic, and are really just trying to claw back as best we can. I mean, my guess is that we're not in a situation of equilibrium right now. My guess is that we will reach a point of equilibrium where we return to what was before, when these services were in the courthouse for easy a referral to tenants who need them. And, landlords too. Landlords use the help center as well. So I mean, that's the goal, and that's sort of like the behind the scenes administrative struggling that, is going on all the time.
And just to expand on that, can you talk at all about the move of the Brooklyn court to Geralman Street, the move of, I see you smiling, the move of the Bronx to the bigger courthouse on 161st Street, and the reopening of the Harlem Justice Community Center?
So the reason I was smiling, the Brooklyn courthouse, landlords and tenants obviously disagree about a lot. If there's one thing they can agree on, is we can all unite against the common enemy, which is 141 Livingston Street. I sat as a judge there for 2 years. It's a horrible facility. I hate that building. I want out of that as soon as possible. And we've basically had an ever receding horizon for when that's going to come out. I think that the responsibility for housing the courts is the responsibility of the government of the city of New York. And so the city of New York was renovating, as Ms. Laurie said, the municipal building in Brooklyn to move the court into. And then I think at some point, it's very shortly before the pandemic, some asbestos was uncovered. So to do an asbestos abatement, when it's the city doing it, requires this like duplicative level, like redundant level of contracting it out and getting requests for proposals that literally put the relocation back years. The current estimate I've seen for relocation of the King's Civil and Housing Court is, I think, February of 2025. For the Bronx, I think it's about the fall of 2026. And I'm not as up on the technical reasons for the relocation of the Bronx. But that's the last time I heard an estimate, that's what I heard that the estimate was. And I am 100% agreement. I think that those facilities are just, it's preposterous to have courthouses in those facilities. And, you know, I feel like I'm banging my head against a wall when we're trying to relocate as best as we can.
And the Harlem court, is that going to reopen or?
The Harlem court presented very unique challenges in terms of that were specific. The last that I heard about this issue was when a lot of the pandemic restrictions were in effect. And so the last that I heard that the Harlem courthouse presented a lot of challenges in terms of social distancing and that kind of thing, that really precluded the reopening of the Harlem courthouse the last time that I talked about it. Now, obviously, since then, a lot of restrictions have been lifted. I'm scrolling through. I apologize. I'm looking because I saw someone explaining what the problem with relocating to the Harlem courthouse was, but I'm not finding it right. But anyway, there were technical issues with the reopening of the Harlem courthouse that were relevant to a lot of the COVID concerns that we had. I don't have it right in front of me right now, and given that a lot of things have changed with regard to COVID restrictions that may be lifted, but I have not heard. I have not heard a change in that, but that's something that I'm interested in making an inquiry about.
And then just to pile on the COVID restrictions, a couple people have asked questions about that. One is, what happens if you test positive on your court date or just before your court date? And then a couple people have asked, just are there still restrictions on coming into the court? Is there any way to make people wear masks? Yeah, so just sort of general, are there COVID restrictions still on the courts? And then what happens if you test positive before your court date?
If you test positive, call the clerk's office, call the court part, do whatever you can to notify us, and you know, we'll adjourn the case. In terms of restrictions, the recent changes have taken away a lot of the restrictions. We're not requiring masks anymore. I personally wear a mask all the time. I'm thrice boosted, but you know, I'd rather not get sick. So I'm wearing a mask, but I see a lot of folks in my courtroom who don't wear masks, and under the current rules, I can't force them to.
Yeah, someone is, just to go back to the Harlem court, someone has posted that it's really unacceptable, all the excuses for not reopening the court. So a couple people have asked or complained about scheduling of HP actions and wondering if that issue is going to be resolved or has been resolved. I'm not sure what boroughs, but apparently people are waiting a long time to get court dates for their HP actions. So I don't have much more detail on that complaint, but
yeah, you don't know which county that is?
No, sorry. Is your sense that people are still waiting a long time for court dates? And if so, is that gonna continue?
I mean, if you want me to follow up on that, I'm happy to do that. But you know, I mean, a lot of what's going on, right? I mean, you know, the mirror image of that is that, you know, I have to meet with every constituency of housing court. I meet with HPD, the tenants organizations, legal services providers, landlords, attorneys, New York City Housing Authority. And it's like the mirror image of the complaint that we're getting. Landlords complain about how they can't get anything that they want in housing court, how it takes forever when cases get adjourned, and it takes forever for them to get decisions. And so, I guess if there are problems with getting HPs on, that's kind of the reverse image of that. I mean, right now we're down judges, we're down court attorneys, we're down clerks. We've had the same attrition issues, to be repetitive, that lots of other legal employers have had. And the consequence of that is that it has an effect on our ability to have X number of cases on particular days. And that does have the effect of pushing calendars out for all kinds of cases, summary proceedings, lockouts, HP actions. I mean, that's a macro concern. If there's a specific borough that someone has had a problem where HP actions are being returnable too far into the future, and you let me know about that, I would follow up and get back to whomever had a question about that.
So there's a question from an attorney who practices in Brooklyn. Do you have any information or details about a possible forthcoming new administrative part that stays or adjourns non-payment cases for 45 days while a tenant or respondent's one-shot deal application is pending with HRA?
I'm sorry. I wanted you to finish
the question. Yeah. The
Sorry.
Brooklyn Legal Service Providers heard at a meeting with OCJ in the court this week that this is something that could be coming down the pipe.
That is a proposal. And the details are still to be worked out because, everything takes forever. But I think it's something that has a lot of promise. And the idea of the proposal is that when a tenant appears in court, they would be referred both to an attorney and for a possible referral to a one-shot deal at the beginning of the case, which is different from the way housing court, the way that one-shot deals used to work, which it used to be you have to wait till you had like a stipulation or an order from the court, which, by that time there's a greater risk of eviction before one-shot deals are applied. Obviously, not all cases can be mooted out by this, but there's a certain percent that are, and the more that there are, the less pressure there would be on legal services providers, because that's like one less case they have to handle, although the tenants would get referred to a legal services provider at the same time. So if there's still some sort of legal issue to be worked out, the hope and expectations that would be addressed too. But there's a certain number of cases that would just be mooted out by a one-shot deal right at the outset. And so that's sort of like a vision for the future. And I think that can be good for a lot of people, because for the legal services providers, that can mean that they can really focus on the cases where attorneys, where the kind of difference an attorney can make is really maximized, because like the holdover cases or the non-payments where payment of money is not going to resolve the issue, where there's a more substantive defense, let's say, like that's where an attorney has the most impact. And so for the legal services providers to concentrate the resources on those is more advantageous to them. To stop tenants from getting evicted is good for them. It's good for landlords. They get their money, if that's the only issue in the case. It's good for the court to have less cases to have to handle in an era with, the challenges of resources. So this is kind of a long-term vision for the court. It's a proposal right now. So there's not a lot of detail to report, because it depends on what HRA is able to do. And it depends on this struggle that we have in the courthouses for space and for a way to physically accommodate this. But like as a long-term, hopefully not long-term, hopefully a medium-term vision, I think it's something that could lead to a vast improvement in all aspects of housing court.
Is there any sense of a timeline on it?
I mean, it kind of depends on number one, finding space, number two, HRA staffing it, number three, HRA getting up and running. The idea is that it would be a pilot program, so that if it works, or if we try it in one place and we find out, oh, this is a problem with the way that it operates, then, hopefully the purpose of the pilot will be so we know what to fix going forward, and to create a model that will spread citywide after starting it in one county.
Someone has just made a statement, very concerned about the increase of default judgments due to venue change. And that sort of echoes some questions that we get on our hotline, which is tenants are confused about whether sometimes where they're supposed to appear, or when they're supposed to appear, or how they're supposed to appear. And I just wonder if you could address the sort of like, are there a lot of default judgments now, more than there had been pre-pandemic? Has that been an issue? You know, people being confused about whether they're supposed to appear remotely or in person, and where in person.
I mean, appearances are, they're pretty much in person now, absent an accommodation. So that I don't know if there are more default judgments now. I mean, are you talking about non-payments or holdovers?
I assume the person's talking about both, but I don't know. I mean, we haven't had them lately, but we were getting calls from tenants who were confused because maybe their case was started a couple of years ago. And so they've gotten different notices about how to appear or how to respond.
So you mean not a new case, but a case that was started before?
Those are the questions that we get. The person who
Sure.
posted this on the chat, I'm not sure. If Mr. Joy wants to elaborate a little, I could finesse the question a little more. Or fine tune it, not finesse it, sorry, yeah. There are some questions about, more questions about ERAP. Is it still helpful for tenants to apply? I understood that the funding had run out after August. Is it?
Yeah, you should still apply. And you know, if you're eligible, you can apply. I'm not going to tell anyone not to apply, because if you apply and then the legislature appropriates money, your application will be in. So, you know.
So no word on whether there will be more money. You have.
I mean, I didn't hear that they were out of money. I mean, that's possible. It's not something that I'd heard, but yeah, that's the call of the New York State legislature to appropriate the money for it. But the program is open and you can apply. And even if there's not money appropriated, you know, if your application is in and then money gets appropriated, your application will have been in, and that hopefully will, you know, solve the problem to a large extent.
And there's another ERAP question, which is this poster understands that a landlord who accepts ERAP can't start a holdover for a year, but he doesn't know what the law is on non-payments. Can a landlord sue a tenant in non-payment and evict a tenant if the landlord got ERAP?
So my interpretation of what the ERAP statute provides is that if you get ERAP, if a tenant gets approved for ERAP, whether the landlord accepts the money or not, a landlord is not allowed to evict a tenant for non-payment of the money for which ERAP approved, whether the landlord accepts it or not. If the landlord does not accept the money, the landlord can't evict the tenant on the ground of non-payment of that money that was approved, but the landlord can proceed with a holdover proceeding. If the landlord accepts the money, then the landlord is not allowed to evict by reason of a holdover for a year after acceptance of the money. But if the tenant owes money besides what ERAP approved, either arrears that accrued before what ERAP was approved for, or arrears that accrued afterward, it is possible for my understanding of the law, my interpretation, and you know, everything. If law didn't have a bunch of wrinkles that are subject to interpretation, we wouldn't need lawyers because everyone would be able to figure out easily. So this is just an interpretation of the law that's subject to challenge, and anyone's free to do that. This is just my interpretation at the moment, is that it is possible for a landlord to get a judgment against a tenant for non-payment of rent, aside from what OTDA may have approved in an ERAP application.
And then another question is, can a landlord raise the rent? If a landlord can a landlord renew the lease with a rent increase after receiving the ERAP payment? Is it true they can't raise the rent for a year?
My interpretation of the ERAP, and again, this is my interpretation, it's not, so challenge it, either side can. My interpretation is the landlord's not allowed to raise the rent for a year. Like I think that the language in the statute is the landlord's acceptance of ERAP constitutes an agreement not to raise the rent for a year. Now, how that intersects with, like, let's say the rent stabilization law, which provides for renewal of leases with rent guidelines board increases. I don't know, that might be an interpretation of two different statutes, and that's one of the legal issues that you said that maybe that's not a legal issue that I myself have researched. I'm not 100% sure. This issue usually comes up in unregulated tenancies, and I feel much more solid ground that with an unregulated tenancy, a landlord can't raise the rent for a year. That's my memory and my interpretation of the ERAP statute.
There are other questions in the chat that I'm not reading. I'll just tell the audience I'm not reading them because they're a little too technical, or they go over ground that we already covered. I'm just checking to see if there's anything that I missed that I think we haven't covered. Here's one also about ERAP. HRA are telling clients if there is a pending ERAP application, the one-shot deal cannot be processed. A client applied after August 2022 and ERAP informed her that she may not get assistance. I know that's a HRA question perhaps, but do you have an answer for this poster?
That's my understanding of HRA's policy. Yeah, is that they want to see that the ERAP application get completed before they entertain a one-shot deal application. And my suspicion is the reason for that is because all these different means of getting rent paid come from different funding streams. And I think that HRA wants to harbor their resources and wait and see what OTDA will pay before they start using whatever finite amount of money they have to stop evictions. That's my speculation on the reason for doing it. And it is my understanding that is their policy.
And then another ERAP question is the landlord is planning on rejecting the ERAP, the tenant qualified. So is it true that the landlord has to wait 180 days before evicting the tenant?
This has come up with me before. The statute gets very specific about this. I don't remember. The last time I dealt with this issue was maybe 9 months ago, and I don't remember off the top of my head the specific details of the ERAP statute. Is this an attorney who's asking the question, or is it a pro se?
I can't tell.
Okay.
I don't recognize the name.
It's been a long time since I've seen this specific issue. I don't remember offhand what the statute says.
And someone who I know is an attorney has posted that she has had multiple clients get approved for a one-shot deal with a pending ERAP application, which just goes to show that in a housing court eviction case, no matter what, if you have an attorney, you're better off than if you don't.
Yeah.
So yeah. And maybe that's just sort of like, maybe their advocates can help as well, in addition to attorneys. I don't have any other questions. If anyone wants to post something super quick, I'm happy to read it out. But yeah, so I don't see any more questions. So maybe we'll wrap it up. Thank you very much, Judge Stoller, for answering these questions today. And thanks to everyone for joining us. We'll have more workshops through the fall and spring, and please join us again. And thank you for joining us today.
Thank you, and I appreciate your inviting me, and I'm happy to speak with you and your organization anytime.
Great, thank you.
Thank you.